So this is a question from Canterbury, from Dr. Chris Jones of Canterbury University. Judge Wainwright, how would you describe the importance of the text in both Magna Carta and the treaty compared to modern interpretations?
Hey, what I was saying is that they were historical documents created in a moment in time for a particular situation, and they have grown in terms of what they are believed to have conveyed, rather than what they actually were conceived to do at the time. I can speak particularly of the treaty in this regard because I know more about it. So the treaty has become emblematic in New Zealand society as a document that is about partnership and the duty of the Crown to actively protect the interests of Māori and to have good government for all its citizens. But it said nothing about that. So none of those words were mentioned. What it did was guarantee in the Māori version, which is quite different from the English version, te tino rangatiratanga of te iwi Māori over their lands and treasures. So most of what we say, the principles connote, is inferred from the language that was used at the time, which was really mainly about, in its essence, it said, we recognise that Māori own the land, and when they want to sell it, they have to sell it through the Crown. That was about the size of it, actually. There was some other language, but none of it was about partnership and active protection and utmost good faith. We have derived from the situation, from what followed, that those principles were inherent in the document. And the same is true of the Magna Carta in the way that Isaac described, that it was for a particular place and time, but it's become resonant in other ways over time.
Thank you. Would any of the other panel members like to make any comments on this question? No? We're okay? Simon, it's a good opportunity. Thank you. Are there any questions in this room? Sir.
Thank you. My name's John. When Hobson proclaimed sovereignty over New Zealand in May 1840, and when the Waitangi Tribunal concluded that Maori had not ceded sovereignty, it caused me to think, what is sovereignty? So my question to the panel, and anyone can answer it, is what is sovereignty and where is it located?
Go, Isaac.
Sorry, what was the last part? What is sovereignty and... Where is it located? Well, being the probably person who's the technical lawyer here, I'll give you a technical lawyer's answer. And sovereignty is the rightful lawmaking authority. And where is it located? Well, at the moment, it is likely to be seen as located in the New Zealand Parliament as the lawful lawmaker authority in New Zealand. So that's your technical legal answer. Whether that's what you're after, I'm not sure, but the other panellists might be able to give a less dry response.
I'm no lawyer. I'd go broader, and speaking on my own behalf here very clearly now, not the minister's. I'd agree with James's definition of it's around who rules, who governs, who structures things. But I would argue sovereignty is ultimately something understood by the people. I know that might go a little bit broad, but we as New Zealanders have to understand what we believe to be sovereign, and if you lose that will or understanding of the people, of who is rightfully there to rule, govern, we run into trouble. So ultimately, sovereignty has a very particular definition, who governs, who rules. Where is it? I would say it's in the minds, the perceptions, the understanding of the citizens of that country. And therefore, at times, it can be a contested idea as it changes. So I hope that's not too broad, but I don't think it ultimately, in my opinion, just sits in one place. Yes, Parliament manifests it, but it manifests it on the will of the people.
If I can just address that briefly. It's true, I believe, that at the time when Captain Hobson declared sovereignty over New Zealand, there was no legal right for him to do so. And the actual legal measure upon which sovereignty was founded was a proclamation from the British Crown that took place after the treaty had been signed and taken to some parts of the country. However, all of that can be challenged through various ways of looking at it. I think my view is that ultimately the New Zealand government had sovereignty because everyone accepted that they had sovereignty. Over the course of the 19th century, there were a number of occasions when Māori didn't like the way that the distribution of power under the treaty was working out. There were the land wars as one expression. There were a number of big hui all around the country where there was dissent expressed, but ultimately it stopped being given expression to, and by the 20th century it was accepted that the people who could exercise power were the people who were voted into Parliament. And in my estimation, sovereignty is about the ability to exercise power.
Thank you. Do we have a question from Canterbury?
They've gone silent on us.
They've gone silent on us. They're probably running from the snow down there, and I don't blame them. We did have another question up the back, I believe. Thank you.
This probably follows on from that question. What does the panel think is going to happen next as a result of the Y1040 report? There seems to have been no response from the government about that, and yeah, I'd like to know what people think will probably happen and what should happen as a result of that report.
You're speaking about the Northland inquiry? Yeah. Well, the Waitangi Tribunal's jurisdiction is a recommendatory one. The tribunal hasn't recommended that the Crown do anything thus far. It has simply put it out there that this is a way of conceiving of the beginning of our nation, under which, according to that tribunal, sovereignty didn't pass to the Crown in the way that it's usually thought that it did. Ultimately, however, and I'm speaking really from my own perspective rather than the perspective of the judiciary or the tribunal, it does boil down to who has the power to exercise authority. And that power resides with Parliament, and I think it's pretty unlikely that Parliament will agree to give that up.
Yes, and I agree with that. I think that it's not going to have the sweeping effect of creating a new constitutional regime in New Zealand, but it is likely to have an emboldening effect on claimants in the Waitangi Tribunal. For example, I know a couple of months ago made frequent use of that in a recent pleading I filed on behalf of clients before that tribunal. So I think it will be used more in that way as another platform or another plank through which a position can be advanced.
Look, I'd just add again, I don't speak for the Crown or the government in these circumstances. As a parliamentarian, was very aware when this came through. I must say I have skimmed the document, haven't engaged in it fully. but as a parliamentarian have had discussions with colleagues, because this, I use the word lens, it's a new lens into how we understand ourselves, and so it's part of an ongoing conversation. I'd have to say my own sense is that yes, Parliament's not going to cede elements of its sovereignty immediately, but I see that the, I'm not sure the right term, declaration, what's been put out there is, again, part of a conversation moving forward, and I'd like to see that as part of that maturing around this whole wider debate as we as a country begin to understand what the treaty means for us, and yeah, that's what part of tonight is as well.
Thank you. Sir, can we get a microphone down here? Thank you.
Kia ora koutou. Thank you for 3 very interesting speeches. I'm interested in whether there's any evidence that any of the chiefs had contact with, basically had knowledge of Magna Carta, because one of the clauses in Magna Carta, I think it's clause 61, it's referred to as the security clause, because the barons were suspicious that King John would not act on the previous clauses, so they had this gang of 15 that would keep an eye on him. And I'm just wondering if the chiefs had some contact or some knowledge of Magna Carta, they might have mistrusted the Crown slightly earlier on.
I don't know. 61 was the one that was quickly dropped from memory, wasn't it, in the first reissue, and the one that caused the Pope to say, well, I'll denounce that, that's an affront to God and nature. So my gut feeling is that they probably didn't, because they'd have had to have gone looking through an awful lot of history books to find that incarnation of Magna Carta.
One of the things that is interesting when you look at the process of the treaty being taken around the Motu to the various tribal centres to persuade people to put their names on it, that the degree of interaction and detail in the discussion that happened in Northland, where the Māori people there had had a prolonged period of interaction with Pākehā, the missionaries and the sealers and the whalers and so on, and they had a pretty strong sense of how the Pākehā did things. You take that situation to Wanganui, where there were no resident Pākehā, where there had been one visit of Pākehā that had happened the previous year. So they'd met previously one Pākehā who was a missionary. And when that missionary, who was Henry Williams, took the treaty there, he had with him a translator, but no one kept a record of what he said. But later, when that translator was taken before the Spain Commission, who was investigating what happened about a land purchase, where that translator had been used, and the Maori people said they couldn't understand anything he said. And so Spain, the commissioner, set up a situation where the interpreter had to speak in Māori, and had Māori people there who all looked at each other and said no, they couldn't understand what he said either. So the chances that anyone was talking about anything of remotely the sophistication of what might have been said by barons in England are nil. In fact, it's most unlikely that any of the key aspects of the treaty were canvassed at all. And Henry Williams would have known from his dealings with Māori that people like these, who had never seen Pākehā people, had no idea how they lived, had no context to put information like sovereignty into, and I don't think he would have tried. What he told them, we think, is that the Crown would protect them from land sharks, because the New Zealand company was there trying to buy their land, and Henry Williams, the missionary, was worried that it would all get bought up for nothing. So that's probably about all that was said. And that kind of scenario contributes to the view of the tribunal that there could not have been an effective handover of sovereignty in situations where people probably didn't even know what signing was. You know, I mean, they'd never seen a piece of paper. So how did they know the significance of putting their signature on something? Probably it was just they were trying to please the white guy who was saying, you know, put your names here, and they wanted a trading opportunity. And so they were doing what he said because they didn't think that there was any downside.
Thank you. I think we have another question, do we, from Canterbury? Yeah. This will be our last question, I think, won't it? Yeah? Very good.
So this question is from Canterbury, from Lindsay Breach. Her question is, do the treaty principles bind the Crown since it must consider them before passing legislation?
Do you want to talk about that?
So I'll give a starter for 10. Do they bind the Crown? They are a mandatory relevant consideration in any executive act. So are they directly binding and directly enforceable as if they were a statute? No. Are they something that must be considered by the Crown in a judicial review, say, a sense, or a good governance sense when a decision is made? Yes. And will they be enforceable on that basis? Yes, if in the appropriate circumstances.
Again, I don't speak as a minister, but from my now second term in Parliament, the nature of the treaty and how it's going to affect legislation is again something that is discussed. It pops up in select committee and discussion in the corridor, certainly in the chamber in debates. It's raised, so it doesn't have that formal structure, which Isaac was indicating, but it certainly plays a part of what we do, and consequently there's a lot of debate at times around particular legislation of to what degree we are honouring, respecting or engaging with the treaty.
I just say that you only have to look at things like the foreshore and seabed legislation to know that Parliament is not under any legal obligation to take into account the principles of the Treaty of Waitangi.
I'm afraid we have run out of time, so I'm just going to turn over to our Konata again to thank our speakers and thank you.
One interesting part of what I've heard tonight, I must add, and it's around the question of did the chiefs have any knowledge of what was happening around them. I want to remind us all that one famous part of the events of the 6th of February 1840 was a statement by a person called Taunui. And Taunui said, "Let us take this document and sign it on the mana of the Kiwi cloak." Of course, the leadership of the time had other ideas. I suppose one could make a comment about Kiwi feathers and another kind of feather that is very topical in Ngāpuhi at the moment. But the choice was made to have the document signed on the Union Jack. From that point, Abrahama Taunui tilted his hat and said to Ngāpuhi, "I will leave Ngāpuhi, I will go and I will locate myself amongst Ngāti Whātua." Now he had written a whole list of his accounts of what transpired in 1840 on the 6th of February, and we believe to this day that Abrahama Taunui had some insight into what was behind and, of course, the whole connection with governance and sovereignty of the British people. So on that note, thank you once again. Thank you to our panels, and if you could give them all a big hand. And of course, to those listening in and tuning in, live web stream, and of course at Canterbury University. Pity we couldn't connect Otago to our discussions tonight, but we'll leave that there for the moment and bid you all farewell on behalf of the University of Auckland, especially Dr. Lisa Chant here and the organisers of this event. Good luck to your deliberations and considerations as we move forward as a nation, and let's hope our descendants are here talking about the treaty in 800 years' time, remarking on the foresight of their forebears. Tēnā koutou, kia tauterangi māni tōra tātou.